By way of quick introduction, I'm an immigration lawyer with offices in Toronto and Montreal. I've been appearing before the board regularly since the year of its inception in 1989, and over the past 2 decades I've represented several thousand refugee claimants in their hearings before the board, so it's from that body of experience that I bring forward these comments to you. My view is that the RAD should be implemented because the RAD is a merit-based appeal, and a merit-based appeal is a necessary component of any proper refugee determination system. I'm also of the view that the RAD should be hearing new evidence, because if we're going to give a claimant the opportunity to present new evidence prior to removal, as we currently do under the pre-removal risk assessment system, it makes much more sense for the RAD to pick up that function, since they already will be hearing the appeal on the merits. And if that's done, then the PRA program, with its 97% refusal rate, can be abolished. In my view, the PRA serves no useful purpose. The best scheme that I can imagine is once the RPD renders a negative decision, CBSA will thereupon begin tentative removal arrangements. That means making sure a claimant has a passport or travel document available, so that once the RAD renders its decision, if it's a negative decision, then the claimant can be removed within 30 days, not after years and years and years, which is the current system today. The thrust of my submission to you this evening is going to be that the RAD should be implemented, but not until the RPD puts in place certain procedural changes.
Mr. Berger, I have one of my senators who's quite appropriately pointed out we're televising this, and many of our viewers may not know what the jargon that we use, RAD and PRA, and
oh, I see.
So perhaps if you can at least once, as he says for the record, once in a while, tell us what those stand for. It would be helpful. I apologize for interrupting.
Of course. The RPD is the Refugee Protection Division. That's the division of the board currently in place that adjudicates upon refugee claims. The RAD is what we're here to discuss today. That's the Refugee Appeal Division, and that is what we're trying to decide whether or not it should be implemented. And the PRA is the Pre-Removal Risk Assessment Program that's also currently in place today. And that's a program where the Immigration Department will give a claimant a last opportunity to present new evidence. So where I left off, I was going to say that the thrust of my submission to you this evening is going to be that the RAD should be implemented, but not until certain modifications are made to the RPD to discourage the flow of bogus refugee claimants coming to Canada. We've seen over the last several years a large influx of bogus claims. The acceptance rate in refugee claims in the first year of the board's operation in 1989 was 88%. That has dropped incrementally, where for the last several years it has been under 50%. My fear is that if we do nothing, what we're going to see is the newly implemented RAD is going to be overwhelmed by bogus refugee claims. And what we should be doing is taking steps to discourage bogus claimants from coming to Canada while leaving the door wide open for genuine claimants to come here. What I'd like to do is very quickly review 2 cases from my own case histories to illustrate the points I want to make. I then want to go over the most recent statistics of acceptance, and I've provided a 2-page handout to you to give you an idea what the caseload of the RAD might be if it's implemented now. And then finally, I want to leave you with 4 recommendations that I believe the RPD and the government should put into place before the RAD is established. A woman from Iran named Fatina Fazeli was my client about 11 years ago. The reason I can give you her name is after the board refused her case, she took her claim and her case to the media, and the Toronto Star published 4 or 5 articles which more or less embarrassed the Minister of Immigration in letting her stay in Canada. Fatina was in my office and for 45 minutes told me in graphic and intimate detail the torture that she endured physically and emotionally in her native Iran. When you hear such a story, from someone who genuinely has been persecuted is something that does not leave you. It stays with you the next day, the next month, a year later, 10 years later. At her hearing, the panel that heard her case, and in those days it was a 2-member panel, decided that they did not want to hear oral evidence from Fatima about her persecution because they already had a very detailed statement. And then they went on to make a negative finding of credibility against her without ever having given her the chance to present oral evidence about her persecution, which went right to the heart of her refugee claim. It was a terrible and shocking decision, made more so because, as I've indicated, it was the worst case of persecution that I have ever experienced in my career as an immigration lawyer, and here the board refused this case. If it wasn't for the Toronto Star and a very brave journalist, Michelle Landsberg, coming to Fatima's rescue, she would have been deported back to Iran and the regime would have finished her off. This is a classic example of why the RAD is necessary. Now, I want to tell you about another very different case. This is a case of a woman called Lul, L-U-L, a woman from Somalia who came to the border with her 2-year-old child. The immigration officer was suspicious about Lul because of her dress and her demeanor. The officer didn't think that Lul came directly from Somalia, as she claimed. But the officer let her in, and I saw Lul in my office, and I remarked to the Somali interpreter at the time that Lul had the most beautiful 2-year-old boy I had ever seen in my life. Now, Lul went on, and it took 1.5 years for Lul to have her hearing. It was a routine hearing, and she was accepted. A few days later, I ran into the interpreter, and the interpreter asked me what happened. I said, well, Lul was accepted. The interpreter said, well, Mr. Berger, what did you think of Lul's son? And I said, well, yes, the boy was there, and he was I said he was a funny-looking, rather unattractive kid. And then the interpreter reminded me and said, Mr. Berger, don't you remember 1.5 years ago when Lul first came to see us, you remarked what a beautiful boy Lul had? And I remembered that, and I was puzzled, and the interpreter was laughing and said, Mr. Berger, let me tell you the real story of Lul. Lul was born in Somalia, but when she was a child, her parents moved the family to Sweden. Lul grew up in Sweden, became a Swedish citizen, got married, had a son, had a domestic dispute with the father of the child, and decided to come to Canada with her child to make a refugee claim. The immigration officer was obviously quite correct in being suspicious of Lul at the border, and he was correct to be suspicious of Lul at the border, and Lul, when it came time for her hearing, Lul had to send the boy back to Sweden. Apparently the father wanted to see the child. So when her hearing came, Lul had to show up at the refugee board with a child. What Lul did is she simply rented a child for the afternoon from the Somali community. And she passed her case. Now, what these two cases show you, senators, is two things. In the case of Fatima, it shows you how easy it is for the board to make a mistake, which could have been a tragic mistake. And in the case of Lul, it shows you how easy it is for a refugee claimant to fool the board. And the reason for that is because the board doesn't ask the right questions and doesn't make the right inquiries. And what those inquiries should be, let me leave you hanging for just a moment because I'm going to come back to that in a minute. I just want to go over the most recent acceptance statistics of the board to give you an idea of what the caseload of the RAD might look like if we implement it right away. And I provided to the clerk a 2-page handout. I hope you have it before you. Now, I remind you that when the board was created in 1989, in its first year of operations, the acceptance rate was 88%. If you look at the handout I've given you, this is for the year 2007. You can see in the accepted column, 5,885 accepted, 5,423 rejected, and 735 abandoned. That is an effective acceptance rate of 49%, or an effective refusal rate of 51%. Now, 51%, Not even the most ardent refugee advocates are suggesting to you that all or most of that 51% figure were incorrectly refused by the RPD. Maybe 10% were, maybe 15% were. But any way you look at it, the overwhelming majority of that figure, of that 51%, were quite correctly refused by the RPD. And my concern is, if we do nothing to stem the flow of bogus refugee claims, that flow is going to flow into the RAD, and just like weeds crowd out the good flowers in a garden, the RAD is soon going to be overwhelmed by a very large volume of bogus refugee claims that were correctly refused by the RPD. So what we have to do, in my view, is we have to take steps at the level of the RPD